Namaste and welcome to the presentation on company formation. As the starting point, we visit the website of Ministry of Corporate Affairs, and based on the steps to be taken to incorporate a new company, if we can list out the steps that they have defined based on their workflow, it simply works down to 7 steps. As a first step, as it is indicated, select the name. Second step, get name approved. Third, draft the memorandum and articles. Then make the filing along with the relevant forms and you obtain the certificate of incorporation. Work on collecting the amount of subscription with drafting and filing of prospectus. Obtain the certificate of commencement of business. A 7-step process which is very neatly brought out in their website. It is quite helpful to us to understand the on-time process, and we have put it in the form of a small workflow for our reference. And if we study the process of company formation, we always find a process like this. Promotion of an idea, selecting the company name, then we do the incorporation after using the memorandum and articles in the filing forms. And if you are a private company or a public company without share capital, you straight away move to commencement of business. On the other, if you are a public company having a share capital, then you come here and you file Form 20A, you file prospectus or certificate of in lieu of prospectus, and then you are ready to get the business commencement certificate. If we look into this entire work starting from selecting the company's name till the commencement of business, it is a large number of functions. And these functions are taken care of by the person who takes care of the promotion of the business. And that is where the promoters as a concept becomes quite interesting. What is promotion? Who is the promoter? It is discovery of business opportunities, then investigating upon it, bringing together men, material, money and management, and to accomplish the objective. That is what is promotion. Going after an idea and converting it into a business proposition. And who is a promoter defined as? He is identified as one in an existing company. He has got control over the affairs of a company directly or indirectly, as a shareholder, director or otherwise. We always say promoter group. And he has got a control over the decision-making powers of the board. That is the reason we call him as the real force behind a company. And what is his capacity as? He acts in a fiduciary capacity. His is not a position of profit because he is looking long term. Therefore, in the course of promoting a business, forming a company, he will disclose his interest and profit as a professional to the core. And as a promoter, his function ends the moment the business commencement certificate is obtained and it the business takes off from there. And we have to observe that if someone is working in a professional capacity, he is not a promoter unless he participates otherwise than as a professional in contributing to capital, labor, and other management skills. Now, this is a brief summarizing on the concept of promotion. When you form a company under Section 3 of the Companies Act, with 7 or more persons, we can form a public company. With 2 or more persons, we can form a private company. And we also can form a one-person company with one individual. And as we already know, a company can be formed as a limited by shares, limited by guarantee, or an unlimited company. Now, when you form the company, the filings that a director or a promoter makes as a part of company formation papers, he has to declare a lot of things about himself. More particularly, during the preceding 5 years, there is no conviction of any offense in connection with promotion, formation, or management of any company, nor has he been found of any fraud or misfeasance. And he also has to declare in the course of his filings that the documents filed contain complete and correct information. And he also gives the address of the office of the company for communication and full details as a subscriber to the memorandum, along with proof of identity and his connection with other firms and bodies corporate with the roles that he plays there with the respective identity numbers. This, as a promoter, how does he get into? Now, along with this, we find the application. The role of every subscriber and what are the documents which are filed to complete the process of formation of company. Now, we are talking of a document called Memorandum of Association at this stage. If we look into the standard memorandums which are available under the Act, we have 5 sets of memorandum which can act as a model for your usage. We have Table A in respect of companies limited by shares, Table B, guarantee with no capital, and so on, Table C, Table D, and Table E. To understand the process better, what we will do is we will take Table A and understand how it works to facilitate formation of a company. Now we have taken Table A and we see its first clause as name clause, which says the name of the company is dash 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 limited private limited. Means it is a simple process of finalizing the name as the first stage. Now under name clause, the name that you select has to be indicative of the main objects of the company, and it should not resemble to any other already registered company, and it should have nothing to do with any unlawful activity in terms of name itself, and we should stay away from misleading names which are disproportionate to the resources of the company. Words like corporation, global, etc. These are the guidelines when you go for the selection of names. Now we have to keep in mind one specific act here now. It is the Emblems and Names Prevention of Improper Use Act 1950. Now that particular act prohibits usage of certain terms and designations as a part of names, and we call it as names which are prohibited. It can take the name, emblem or official seal of UNO, WHO or Indian national flag, or of any department official seal or emblem, emblem or seal of the President, Governor of the Republic or Union of India. At this point I have to just draw your attention. When one TV was being launched, news channel, Mr. Subramanian Swamy, he raised a question using the word republic. He said the word republic as a part of the name might not be permissible under the Emblems and Names Prevention of Improper Use 1950. It didn't go further. Just for the sake of interest, I'm just saying. And it should not show any pictorial representation of the positions of power or the father of the nation, medals and badges, and any name which suggests patronage of Government of India or Government of State or any local authority. We should take care when we select a name, it doesn't attract these things, and we stay clear of this. Then, as a requirement of the name has to end with the term limited or private limited, depending on the nature of company that we are floating. And the Ministry of Company Affairs says select up to 6 maximum names and indicate your preference so that you have got a choice of preferable names and alternatives. And selecting name being the first activity is quite wonderful, as it symbolizes a lot of things so far as a company is concerned. Thus, name clause, when we see these things, we get to know that as per the Act, the name of the company gets affixed at the registered office, outside every office in a conspicuous position, and it will also be expressed in local language plus one more language, and it will be printed on all letterheads and contracts, invoices of the company. And the name of a company can be changed by following a process, and that process involves passing a special resolution. A special resolution is one where the vote cast in favor is more than or equal to 3 times votes cast against it. And approval of central government in writing is required. Special resolution plus approval. And by changing the name of a company, your rights and liabilities remain unchanged. They continue with the company. And any alteration has to be filed with the registrar of companies, and he has to issue a fresh certificate of incorporation for the purpose. And when we say central government has to give the approval, in fact the power is delegated to the regional director, and who will take care of that. And whenever he gives a decision on the name, on its change, as an authority of quasi-judicial nature, he will record reason for the order. Now, as per section 16 of the Act, the change of name requirement takes place under 3 circumstances. First circumstance, when central government finds that the name chosen resembles an existing company, in that case, it will give 3 months time to the company and then say, just change your name. It's an instruction from the central government. And the company has to change the name of itself by passing an ordinary resolution. Means when it is an order from central government, do it in 3 months. Pass an ordinary resolution, go for a fresh certificate of incorporation with a new name. Second, when the name chosen and registered is found to be an infringement of trademark, the government will give you some more time. Instead of 3 earlier, it will give you 6 months. And you can once again go for rectification of the name and change of name in 6 months by you following the same procedure of ordinary resolution and filing. But there is one third situation where company wants to change. Now, when a company wants to change its name, the process involves interest of employees, customers, creditors, government, and all these things are to be taken care of to understand really what is the motive of change. To safeguard the interest of all, the Act provides for there should be a special resolution passed by the members of the company. Number 2, there should be an approval of central government before making any change. Third, after first and second stage are over, then they can file the document. And they can take the time what is involved in the process. These are the 3 types of changes of names of a company which happens in the normal course. And we have to remember one thing, when we write the name of the company, we should be very careful. The name has to be spelt exactly as it remains. If you belong to the company and you enter into contract with the wrong spellings of the name, and if there is a liability, the liability will be on the person and it will be a personal liability. And one more interesting condition is that when a company changes its name, the name should be indicated on all the records and invoices and other things as both old and new for a period of 2 years. This is for the sake of two reasons. One, for continuity, and number two, for avoiding any confusion. Now if you go to table A and look into the second clause, which is a registered office clause or location clause or situation clause, and the clause reads, the registered office of the company will be situated in the state of. We have to remember one thing. The situation clause talks of the state of location. It doesn't talk of the proper address. Have you seen this? We go to the section 12, which deals with the registered office, and let us see what it talks about. As we noted, it talks of the state, and it should have a registered office of its own for receiving all communications. When a company is incorporated, it is given 30 days to indicate its registered office for the delivery of letters and other communications. And within these 30 days, the company has to file its address from where it is operating its offices. Now, when it gives the location of office based on the address, it has to give proof that the tenancy contract or supporting papers are in favor of the company, and therefore either the premises are owned by the company or they are on lease or rent and supported by documentary evidence. And we have already seen the name of the company will be quite visible at the registered office in the place of business, legible letters, engraved on seal, and all your documents will be showing, that is, letters, billboards, notices and other publications will carry the office of your registered office along with corporate identity number. Now this is the second clause of registered office, which is to be ready for communication within 30 days of incorporation with documentary evidence. Now, can a company change its registered office? Now here we come across multiple situations. We can change the registered office within the state, from one city to another, and the process is simple. You pass a special resolution and give notice of the change to registrar within 30 days. It is simple and straightforward within the city. No change of the ROC also, just an intimation. Thereafter, we have got transfer within the city, within the state, but from one ROC to another. The registrar of companies changes within the state from one location, it might be going to other location. In that case, it says you should have a board resolution of shifting Secondly, there should be a special resolution of members. And when you are shifting from one ROC to the other, there are certain controls. Two directors authorized by the board have to give a declaration that there are no dues in default to workmen and creditors. And all their cases and litigations will continue with the present jurisdiction of court only. And they have to give a copy of the letter to the State Chief Secretary for its implication on labor, more particularly. And against the application, with these details, the regional director, because it is moving from one ROC to the other, therefore the application will be to the regional director, he will give the response in 30 days. Once the regional director gives the communication, the company will file with the ROC in 60 days, and within 30 days of its receipt by ROC, the Registrar of Companies will issue a fresh certificate of incorporation for the changed, and the change takes effect from the date of the certificate. Thus, we have seen here change within the state, one city to another and one ROC to another. Slightly complicated when you move from one ROC to the other. Now there are situations where you move from one state to another state. Now when you are moving from one state to the other, application has to be filed. A copy of the resolution of the board, and there is a specific format for this, has to be filed by the company with the ROC and also Chief Secretary of the state. Since it is moving from one state to the other, its financial commitments become more important, and it has to take care of the requirements of amounts due to debenture holders, creditors, others. The directors have to certify a list of creditors and confirm that the list is exhaustive and it covers all claims. Now, why this is done is to protect the interest of people who are involved because of the movement. It is not to doubt the intentions, but it is to protect their interests. What the process requires is the company has to issue an advertisement both in English and vernacular, enclosing a copy of the application stating the intention to move from one state to the other. And the advertisement will also expect or welcome objections from those who are concerned. And a copy of the advertisement along with the application is sent to both ROC and Securities Exchange Board of India. And once the advertisement is given and objections are received, central government representative will hold the hearing and ask the company to implement the decision taken at such hearings. And the central government thereafter, within 60 days, having satisfied itself that the alteration has the consent of creditors, company has made enough provision for protecting the interests of the creditors, and adequate security is also available in the event of payment to be made. The central government order will be filed by the company with the ROC of both states within 30 days, and the fresh certificate will be issued by the registrar of the transferee state or the new state where the company is going to be. Means, as the movement goes from state to state, central government is involved, two ROCs are involved, creditors' interests are taken care of, Chief Secretary of the state is also involved for its feedback. Thus, we have seen the movement of registered office of a company within the city or from one city to another, from one ROC to another, and from one state to another. Now let us go to the third clause of table A, which is known as objects clause. Now if you look into it, is simple two-line statement in a memorandum. It says the object to be pursued by the company on its incorporation are, you will put your main objects, manufacture of automobiles of horsepower, so much of capacity. Then second type of objects, matters which are necessary for furtherance of objects above. This is objects clause. It clearly defines what the company is going to do once it gets into business. Now, third clause of the memorandum is the objects clause, and we have seen it is so simple. Learning more about it, let us take one by one. When it comes to choosing the objectives, you are starting a business and you have got full freedom to choose what you want to do because it is an adventure and a venture. But as we saw, object should be legal. You start a company for doing a legally acceptable business. Therefore, it should stay away from activities which are objectionable like gambling, lottery, etc. Why the statement of objects is important? Money will flow into your business depending upon what are you going to do with that. That is decided by your objects. The risk element in any business is linked 100% to the objects of the business to start with. And it is always monitored. Whether you take a loan from the bank or you go for an IPO into the share market, any money that comes, it has got to be spent on the project properly explained while collecting the money. And the project depends upon the object of the company. And a proper definition of objects ensures that we remain focused very sharply on whatever we do. Going forward, can we change the objects? Now, when it comes to name, location, the restrictions are less. But when it comes to objects, the restrictions are very, very harsh because when you have collected money, you have collected money for a specific purpose. Investors have put money in your company for a specific reason. But if you now want to change your objects and go altogether in a different direction, it is a very, very major decision for people who have invested with you. Their comfort level is affected. Now, therefore, there are restrictions on changing objects of a company. More so when the company has collected money and it has got some money still not used on the project. Now it wants to start some other project and then put that money into it by changing the objects clause. Now here there is a concept called special resolution through postal ballot. It is not calling a meeting in a specific place. Every shareholder is intimated and his vote will be sent to the company as a postal ballot, and the postal response received by the company has to be a special resolution, that is 3:1, 25:75. And when the special resolution has to be passed, besides the notification sent to individual shareholder, details are published in the newspaper, one English and one vernacular, stating that the company wants to change its objects to the extent of the amount it has got now, and it wants to do this change. Even when a special resolution is passed and it is okay with the change, there is investor protection intention here. The dissenting shareholders are given an opportunity to exit as per SEBI regulations. Now, the ROC, once the special resolution is passed and filed, he will proceed and he will process the request within 30 days. And here, because of the special resolution through postal ballot and also newspaper advertisement, there is no meeting or specific discussions with creditors, bankers, others as a procedure required. Now this is regarding objects and change in the objects of the company. Now there is a concept called Doctrine of Ultravires. What is ultravires? Object of a company are stated in the memorandum. Object acts as the major boundary within which the company has to operate. Company may do an act which is necessary, incidental for attainment of its projects, and it is authorized by the act. And if it does something which is beyond the objects, it is beyond its powers. Any action which is outside the memorandum is called ultravires, beyond powers. Because objects are a big compound within which the company has to operate. If it wants to do something outside the boundary defined, it is not permitted. Anything done beyond is wholly void and it is not binding on the company. And this is the principle of ultravires. And if it is ultravires, which is not the power of the company, there can be no suit on either side. Neither the company can sue nor others can sue the company, because company had in the first place no authority to do that act at all. Therefore, whenever dealing with the company, people look into memorandum and find out, is this within the objectives of the company? Is it intra-vires? If it is ultra-vires, it is risky. Now we can have a few principles in respect of the intra-vires and ultra-vires. If it is ultra-vires, the company beyond the boundary, it is void. Shareholders or nobody can ratify it. It is a gone case. Sometimes it is within the powers of the company, but beyond the powers of the directors. The directors decided without having powers with them, but the company had powers. We call such situation as ultra-vires, the power of directors. It was beyond the power of directors, but within the power of the company. It can be ratified by shareholders. And there is still another situation. It is ultra-vires the articles, but within the power of the company. Since it is clashing with the article, company can change the article and make the act as valid act. Just to say, what we need to do is, we have to ask the only main question: is the act within the powers of the company? If it is within the powers of the company, we can either ratify it, we can alter it. But if it is beyond the powers of the company, it becomes ultra-vires. You can't do a thing about it. This is regarding acts of the company beyond its powers and its three variants. Let's go to the fourth clause of Memorandum of Association. Liability clause. Simple clause. If you read that, the liability of members is limited, and this liability is limited to the amount unpaid, if any, on the shares held by them. Simple clauses. We make it complicated. All documents to start with, simple, plain and understandable. Now, let us go to see some details about the liability of members. In company limited by shares, the position is very, very simple. Liability is limited and it is restricted to the extent of unpaid amount on the shareholdings. You hold 100 shares, 50 rupees already paid, means your liability is balance 50, which is unpaid. Okay. In case of a guarantee company, in guarantee company, the liability is when the company goes bust. The amount is 1, you will pay to the assets of the company in case of winding up, and it will be within 1 year after he ceases to be a member. Even after he closes to be a member of the company, his liability runs for 1 more year and he has to contribute as number 1. Number 2, anything the company has contracted during his tenure as a member till the last day of his membership, he is responsible to contribute towards it. Number 3, when a company is wound up, it will incur charges and expenses. He has to contribute to that also. Therefore, as against a limited liability company by shares, in a guarantee company, you contribute to assets, you contribute towards debts and liabilities, you contribute even 1 year after you cease to be a member, and you also participate in owning the expenses of winding up. Let's go to the fifth clause. Fifth clause is the capital clause. Here also, the clause reads in the table A, which is meant for company limited by shares, the share capital of the company is rupees so much, total capital, total kitty, divided into n number of shares of rupees each nominal value. Three things it talks of. One, what is the total amount? Say 10 crores divided into 1 lakh shares, let us suppose, of how many each? 10 crores divided by 1 lakh, so many shares of rupees 5 each or 10 each, the way we put it. It is simply a mathematics of taking the total kitty of capital, dividing into shares and their face value. Now, in case of a company having share capital, it has got a registered share capital. As we saw, total capital, division of share of a fixed amount, number of shares which the subscribers agree to subscribe, and in the memorandum, when a subscriber signs, he shall take not less than 1 share. And we will come to that clause wherein we will write against each subscriber how many number of shares he is going to take in the registered share capital. And it will be written against his name, and it is a part of subscription clause which will follow. And if you look into capital, a public limited company should have a minimum of rupees 5 lakhs as paid up capital to start with. And if it is a private limited company, its capital has to be a minimum of 1 lakh or such higher amount as prescribed by articles, but it has to be 1 lakh and above. In case of one person company, this clause has to state who will be the nominee, which we have seen when we were discussing about the one person company. Now, there is a sixth clause known as association clause. In association clause, each of the members, you will find name and address, occupation of the subscriber, serially, number of shares he has agreed to subscribe, his signature, and there is a witness. And in this association clause, if you read, there is a declaration. We, the several persons whose names and addresses are subscribed, are desirous of being formed into a company in pursuance of this memorandum of association, and we respectfully agree to take the number of shares in the capital of the company set against our respective names. This is the contract. The memorandum of association, with its 6 clauses, comes to a conclusion with an association clause where the members express their intention and confirm it in writing that they want to be formed as an association, and they will be taking number of shares mentioned against their name, and this is signed in the presence of a witness. Now, this is the 6th clause of association clause. We have looked into the declaration of the subscribers, and in case of a public company, since the minimum number of members is 7, there should be 7 subscribers signing the memorandum and taking the shares. In case of a private company, since the number of members is 2, 2 people have to sign for it. And each subscriber must write opposite his name the number of shares he takes and sign the document. And he should take a minimum of 1 share. It is specified there. And Once you sign the memorandum and the memorandum is filed with the registrar of companies and it's registered, the contract is done. You cannot withdraw thereafter. But before the memorandum is actually registered with the registrar of companies, it is no more a contract. It can be withdrawn. It is a matter of offer and acceptance. Before the ROC conveys its acceptance, it can be withdrawn. But once ROC accepts the papers, registers it, whatever you have agreed under the association clause, it shall be binding on you. This is regarding the association clause of a memorandum of association. Thus, we have taken you through the memorandum of association of a company limited by shares with its 6 clauses: name, situation or registered office or location clause, objects clause, liability clause, capital clause and association clause. Situation clause is also called domicile clause. This is how an ideal table A looks like in a company limited by shares, and this document is required to be prepared for the sake of incorporation of the company. We will proceed from here and understand that can a memorandum by altering create a breach of contract. It all depends on the construction of the court. If the company alters in breach of contract, we have seen it alters the name, objective, liability, everything. There is a process. But if that is going to hurt the interest, the courts may restrain the company from altering the position. No company can increase the liability of its members. For example, in the association clause, we have agreed to buy X number of shares and then its face value is so much. By using its majority, a company cannot change the articles to increase the liability of its members. It's possible only in one case, where he consents in writing. This is just talking of a situation where what a company can do, what it cannot do. Any alteration of memorandum is a matter of good faith. If it is not done in the interest of the company and in the interest of the members, it is a fraud on minority which will not be acceptable. And no alteration of a memorandum should constitute a fraud on the minority. Now let us come to Articles of Association. We have seen till now the first document, Memorandum of Association, which defines the boundaries. Now we are building up another document called Articles of Association. What is this articles? Articles are internal guidelines, and it talks of bylaws for relation between company and its members and members inter se. This is more to do with how do we interact within a company, whereas memorandum talks of outside, how far the company can operate, what is its boundary. This is within the playground, how are we playing the game? Articles define that. We call it as Articles of Association. Now, we have to see that articles are subject to Companies Act. We cannot disobey and pass a rule internally saying we will do something which is contrary to Companies Act. We have to just see Companies Act is on the apex. Anything that we do has to be in obedience to Companies Act. If we do something against it, it is simply inoperative and void. Therefore, when you have internal rules, ensure that it is in line with the demands of the Companies Act. For example, Section 272 says a shareholder can apply for winding up, but you can't have an article's internal rule stating no shareholder can ask the company to go for winding up. No, because it contravenes a right given by the Companies Act. Now, Section 123 says company can declare dividend only out of profits. But if company passes an article stating company can distribute dividend from any sources, that contravenes the act. Therefore, articles has to be following the act 100%. And regarding articles, this particular line makes a lot of sense. Articles of association has to be divided into paragraphs. It has to be consecutively numbered, signed by every subscriber in the presence of at least one attesting witness, and both of them adding their occupations. Just like we have seen an association clause in the memorandum, articles are also have to be in the same fashion, and articles also can be changed by passing a special resolution of members. These are all internal rules which can be changed. But first article of association once again has to be signed by all the subscribers. And just like we have seen in case of memorandum, there are standard tables given by the Companies Act. In case of articles, for companies limited by shares, we have got table F. Table F gives an ideal article of association which we can adopt, and without contravening the provisions of the Act, we can improve upon it. We will make use of this table F for a typical understanding of it. Articles, what are articles? And what happens if they go against the Act? And how articles are to be structured? What is the model set of articles available? Now, this is table F, which is given by the Act as an ideal article of association for a company limited by shares. What does it contain? Mainly, it contains rules on share capital, transfer, transmission, voting rights of members, general meetings, variation of rights, dividends and reserves, capitalization. Directors, how are their meetings held, how frequently, what powers do they have in the meetings, what are the powers of CEO, manager, secretary, CFO, all internal people, and how common seal has to be applied, what is the procedure, what are the levels of authorities, accounts and audit, how frequently the audit has to take place and how to appoint the auditor, what are all the terms, winding up proceedings, how is the procedural thing. And if you go through all these listing takes care of this. It starts from interpretation, goes till the indemnity, secrecy, winding up, etc. We have taken a few clauses. For example, if you take a clause in table A, proceedings of directors, it says directors may meet either in person or through video conferencing from time to time and meet at least once in every 3 months. It is a rule. It is called an article. Similarly, we have another thing which says directors may from time to time at their discretion borrow for the purpose of company's business. This is regarding their borrowing powers. Then we have taken some more dividend and reserves. The company in general meeting may declare dividend, but no dividend shall exceed the amount recommended by the board. This is an article of association. Then comes indemnity and responsibility. Means each of these paras are a part of it. Table F, proceedings of directors, dividends, indemnity, and we have share capital, we have alteration of capital, we have forfeiture of shares, and votes of members. All these put together are different clauses of articles. So, do articles contain names of directors? Yes. The first directors of the company are named in the articles, and the articles will name them, and their details will be filed with the registrar of companies. Name, surname, family names, director identification, interest of the first directors, and their consent to act as directors in a specific form, it will be done. Then, alteration of articles. Can we change the articles of association? Yes, by passing a special resolution, we can change the articles. But any change that you do will apply only for future. It cannot be from the past. It will not have retrospective effect. Only thing, you can alter articles, but you have to obey two things. All powers of the articles is subject to memorandum of association at one level. Second, both are subject to Companies Act. Therefore, on the top is Act. Then you have got memorandum of association, and that is followed by articles of association. Any articles which are indicated as rules, they cannot go against memorandum of association and the Companies Act. As we have seen, both memorandum and articles shall be signed by each subscriber to the memorandum. Where the subscriber is a body corporate, the body corporate can nominate an authorized representative to sign. Only condition is that he can't have a double role. He can't say, I will be signing in my personal capacity and I will sign once again in the name of the body corporate. It is not allowed. He has to be either a subscriber or a nominee, one of the two. And full details of every subscriber is filed with the ROC. And also of the body corporate which is nominating. This is regarding subscriber details and how it is implemented. Now we have got two principles which we need to understand very clearly. One is of constructive notice. See, memorandum and articles are filed with the registrar of companies. Once you file with the registrar of companies, anybody can go to registrar of companies and pay a small fee and collect those documents. They are open to public and become public documents. What do you mean by public documents? Public documents suggest that people have full knowledge of them. When you are dealing with a company, you should be aware of the company's memorandum and articles of association before you deal with them, so that you understand what is their boundary and what is their internal rules. These two things you should be aware of. Now, you will find it quite interesting here. It says, a person dealing with the company is taken not only to have read the documents, but to have understood according to their proper meaning. Means once it is a public document, it is just like a law. You have got a saying, ignorance of law is no excuse. Ignorance of contents of public documents is no excuse. Whether he reads it or not, Whether he has understood it or not, the presumption is it is a public document, therefore you know the proper meaning of it. We presume that you are aware of the contents of memorandum and articles, and that notice is known as presumed notice, and it is also called constructive notice. You can just see here, as per Articles of Association, a document was to be signed by 3 people: MD, Secretary and Working Director. Whereas our gentleman in the particular case accepted a deed of mortgage signed by only 2. Now, company says you received the document, and as per our open document, public documents, it was to be signed by 3 people, and that is your constructive notice. If you have accepted a document without 3 signatures, then you can't claim under the deed. Court said yes, it is to be under constructive notice of memorandum and articles. This is the doctrine of constructive notice. Corresponding to this, there is one more doctrine called the Doctrine of Indoor Management. For example, article says to borrow 100 crores, the company should pass a board resolution. This is as per articles, and bank has received a board resolution. But within the company, they have a mechanism that there are 3 committees. Committee 1 studies it, recommends it to committee 2, and that goes to the board of directors who pass the final resolution. Now, this is internal. This is not evident in the Articles of Association. I am supposed to know what is published openly. What is secret inside, I am not aware of. This is called Doctrine of Indoor Management. An outsider is not supposed to know what happens within the doors, and the outsiders are protected. Doctrine of Indoor Management is quite the opposite of constructive notice. This is for open document, this is for closed doors. If your doors are closed and it is not open to me, then I am safe against any mistakes that you do. This rule came into picture in the Royal British Bank versus Turkand, but its application outside is quite less, but it protects a stranger, while a public document like memorandum and articles exposes you to risk because you are supposed to understand it the right way. This protects you from things which happen as a procedural aspect within the company. These are the 2 doctrines of indoor management and constructive notice. What is the relation between articles and memorandum? Here it is quite interesting, you understand. Memorandum talks of an objective, it talks of a purpose. It talks of what? Purpose. What is to be done? What is the objective of the company? Whereas articles, it talks of not what, how it has to be achieved. You are given a big playground, that is what. Whereas you are supposed to play inside the playground, how? This is the relation between the 2. And who is bigger and who is smaller? Memorandum is on the top, and article is subordinate to it. If there is a fight between the 2, memorandum prevails and articles must give way, because article is subject to what is given by the memorandum. The memorandum is the area beyond which the action cannot go. Inside that area, shareholders can act the way they like. Articles can play within that area, they cannot go beyond that. As we have seen, memorandum can be altered, but it requires a lot of approvals, central government approval, public notifications, hearings and all that. Whereas articles can be changed by a simple resolution, special resolution, not simple resolution, by a special resolution. And as we have seen, on the top is Act, just below that is Memorandum, and just below that is Articles. That is the hierarchy that we have. And as we have seen, in case of ultra vires powers, if the company does something beyond the scope of objects of memorandum, it is absolutely void because it is ultra vires. It cannot be ratified. But whatever is done by articles, but within memorandum, it can be ratified, and it is just an irregular act. Now, when we file these memorandum and articles and a declaration in Form 1, and there is a Form 18 which is filed, which is for a declaration by subscribers to the memorandum. As we have seen on the 5 years, any offense and punishments, address for communication of the office, and consent to act as a director. When all these put together are duly signed and presented for registration, the registrar, on the basis of documents, shall register all these 4 documents, and he will issue a certificate of incorporation. And once he issues a certificate, the company all of a sudden comes into existence. Incorporation is the process of bringing the company into existence. And once it is registered, company will give a corporate identity, registrar will give a corporate identity number, and it is included in the certificate of incorporation, and the company comes into being with a birth certificate. That birth certificate is nothing but certificate of incorporation. These are the that we file, and certificate of incorporation is just like a birth certificate. It declares that the company is born, and from that day, that certificate helps the company to operate as an independent legal entity. When we say separate entity, artificial person, that comes into picture once the certificate is issued. At this point in time, we have created an entity which is different from members, which is artificial, separate legal entity which can sue and be sued, and its date of birth is mentioned in the certificate of incorporation, which is conclusive. It is free from all defects. Once a certificate is issued, it is final. It cannot be withdrawn. It is called, that is the reason we call it as conclusive evidence. It says this association is duly authorized and registered under the Act. And even if there is a defect in the course of registration, once the certificate is issued, all those things are sidelined. Now you will ask a question, if there is a major defect in the whole process, then they say, if you have created a company, you have to destroy it in the normal way of winding up, and then you can create one more new company. Therefore, if you cannot, if there is a company which is created for an illegal object by mistake, you can't say certificate of incorporation is conclusive evidence, we can't help it now. You can help it, because illegal objects, you can't have a company made for it. But what you need to do is, you have to wind up that company, means you dissolve the company. That way you cancel the certificate of incorporation and another entity comes into picture. Once memorandum and articles are registered, they bind the company and members as if company has signed with each and every member, and whatever the members have signed in the memorandum to contribute to buy the shares, that becomes a debt from that date. And one thing you have to remember here, just like we maintain our birth certificate, all papers, copies of documents presented for registration will be maintained by the company throughout its life as a permanent record. Copies of all documents. It is not a memento, it is a statutory requirement. This is the beauty of how a certificate of incorporation operates and how it takes forward. This is the certificate of incorporation, which is simple. The ROC says, I hereby certify that company limited so and so is this day incorporated under Companies Act 1956 or 2013, given under my hand in Madras on this particular day of January 2000, and with the seal of ROC. This is the certificate of incorporation. In the process of company formation, we have come up to certificate of incorporation. And now only one aspect remains. What happens if the company has made some contract before it came into existence? Can someone claim rights under that? It's very, very clear. Company can contract only after the incorporation certificate is issued. If there is some contracts done before, it is not binding on the company. No contract can bind a company before it comes into existence. It cannot be sued on pre-incorporation contract. Now the beauty of it is a solicitor helps you in incorporating the company and he sends you the bill and you say this is a bill pertaining to pre-incorporation and I will not be able to pay. The logic is company was not in existence when the expenses were incurred, therefore it cannot ratify pre-incorporation contract and it cannot sue on pre-incorporation contract also. Means it doesn't have rights, it doesn't have liabilities both in respect of contracts before incorporation. But there is a remedy under section 15 of Specific Relief Act. The Specific Relief Act says if the contract was made before incorporation and it was required by the terms of incorporation, just like the advocate's fee, it is required by the terms of incorporation that we take his service. The company can adopt and enforce it and pay because it is required by the terms of incorporation for the purposes of the company. And one more thing we have to see, if any contract is made prior to incorporation and it doesn't qualify under Specific Relief Act, the person who made the contract will be personally liable. And if the contract is made on behalf of a company not in existence, the agent might incur personal liability. That is how it works. Thank you so much. Thanks a lot.